Hello, welcome once again to Lehto's Law. I'm Steve Lehto, attorney at law in the state of Michigan, and today we're going to talk about something that was pointed out to me by David, a viewer of this podcast. Thank you, sir, for passing this along. But it was an article out of Bloomberg Business Week called "Sign Here to Lose Everything," written by Zachary Miter and Zeke Foe. If I mispronounce your names, I apologize. Both writers have the first initial Z, which is pretty cool, though. And they're writing an article about a confession of judgment scheme. Confession of judgment. And it's a legal concept that even a lot of attorneys aren't that familiar with because they don't happen that often, at least not outside of New York, where apparently this is something that's a booming business. So what this is you have to understand it's going to be aimed at businesses, but not just businesses in New York, but businesses around the country. But if you're in business and you have cash flow problems, you might be able to go to a bank and borrow money. And if your business has some kind of evidence that you can pay the money back, they might lend you the money. Problem, of course, is if you can't borrow money from a traditional lender, what do you do then? Well, there's businesses in New York that will contact you. Apparently, they actually chase people down with fax machines, with emails, phone calls, and they'll say, hey, look, we can lend you the money, the bank won't lend you. But they say, however, it's not really a loan. See, loans are capped based on usurious interest rates. And so we can't lend you the money we'd like to at the interest rate we'd like to because that's illegal. So what we're going to do is we're going to give you what's called a merchant cash advance. And by calling it a cash advance, they're basically saying we're buying your future income stream. It's no longer a loan. So the interest rates go out the window. So what will happen is they'll say, we'll lend you this money. And it might even be six figures. We'll lend you quite a bit of money. But the thing is that to pay us back, you're going to be making payments to us weekly, possibly even daily. And they may actually ask you, for instance, to set up an automatic daily withdrawal from your business account to make the payments on this merchant cash advance. It's not a loan, merchant cash advance. And so what they'll then say is if you agree to this, we're going to send you some documentation. You sign the documents, and then we'll send you the money. We'll be on our way. And they'll send you the loan agreement, but they'll also send you a thing called a confession of judgment. And people see this, and it's just one of many legal documents. They just sign it and send it back right along with the loan agreement. Now, any attorney would tell you, never do that. Don't ever do that. The problem, of course, is that very few of these people ever consult attorneys, especially on things like this, until it's too late. And here's the problem. A confession of judgment is a document that it has a legal effect in New York. Many states have outlawed them, and in fact, they're not ever legal in a setting where it's a consumer loan. But in business loans, they're apparently still legal, at least in New York. So a lender, a merchant cash advancer in New York, asks you to sign the confession of judgment along with the loan agreement, not a loan agreement, merchant cash advance agreement. And you sign these documents, you send them back, and they send you the money. Well, here's the problem. A confession of judgment is a legal document that says, I, the borrower, and I'm going to use that term simply because it's easier, agree that if I default in my agreement with you, the lender, you have the right to take this piece of paper that I've signed into any court of competent jurisdiction in the state of New York, and simply with an affidavit from you saying that I've breached the agreement, the court can then issue a judgment against me in favor of you for whatever you say I owe you. And I agree to that when you give me the money. And it's a crazy concept because as the authors of the articles point out, it's something that seems to call for abuse. And in fact, the quote is, not surprisingly, some lenders have abused this power. And so it's an interesting concept, but people go, where did this even come from? A confession of judgment? Well, a confession of judgment has been part of the English common law, according to the authors of the article, and it goes way back. And it's designed to short-circuit those situations where a trial wouldn't be necessary. I mean, if I owe you the money, why have a trial over it, right? Of course, that's not what trials are for. Trials are usually to determine whether or not there was a breach. But it's another story altogether. As the authors of the article point out, the confession of judgment was actually one of the plot points of the Pickwick Papers, Charles Dickens' novel published in 1837, which, by the way, is the same year that Michigan became a state. And federal regulators banned them for consumer loans in 1985. Now, here's the thing. Despite the fact that they're no longer legal in consumer settings, and many states don't even recognize these things, states do recognize judgments. So if somebody in New York gets a judgment this way, they can then take the judgment into another state and collect on it if they want to. But it turns out they often don't have to. So in this very good article, and like I said, I'll put the link below so you can find it, they talk about how many of these merchant cash advances, if they were actually described as loans, have percentage rates that are over 400 or 500%. Okay, monstrously, almost loan sharkish rates. Not sure if I've ever used the word sharkish before, but because these are merchant cash advances, they're considered legal. So the bizarre thing about this is that the authors of the article in Bloomberg Businessweek tracked down people who said, I got a merchant cash advance from a company in New York. I was making my payments, and next thing I know, my bank account was frozen, and then money was taken out of my bank account, and more money was taken than I even owed. And besides, I hadn't breached the agreement. But the problem is, you don't get to make that argument anymore because you already consented to a judgment against you, and the judgment's already been entered, and it was entered in New York. So when the authors of the article were looking around for people to talk to about this, they found them in all over the country. They found them in Puerto Rico, Florida, other states, Michigan. And the interesting thing is that the confessions aren't enforceable in Florida, where one person that they interviewed resided. But New York courts are especially friendly to confessions and will accept them from anywhere. So the lenders require the customers to sign documents allowing them to file them in New York. So let's suppose you're in Florida. Florida's got a law against these things. Like I said, the confession is not going to get enforced in Florida. It's going to get enforced in New York. It'll get turned into a judgment, and a judgment will get full faith and credit in all 50 states. So the weird thing about this, as they pointed out, is that this appears to be fairly new. Going back to, like, say, 2012 or 2011, there were very, very few of these being entered in the courts in New York. And they have a graph, and it's one of these graphs that goes like this, where it starts off almost horizontal and ends almost vertical, to show how this has grown into a billion-dollar industry. And it appears that there are some lenders that are doing this more than other lenders. And the accusation is that some of these lenders actually aren't even waiting to see if people do comply with the payments. They just say, something, let's just take this one, turn it into a judgment. And that's the problem. There are some examples that they give of people who say, I was making my payments and they defaulted me, or they got the judgment against me and they got way more than I owed them, but again, had no right to argue about any of this because of the fact that I signed the confession of judgment that said specifically that I agree to a judgment being entered against me. So it's going to happen. It happened. The authors of the article point out that in 1 month, a single clerk's office in Orange County, New York, issued 176 judgments against small businesses in 38 states and Puerto Rico. And that's on these confessions of judgments. So, I think I've mentioned before that I've had a thing called a consent judgment. And a consent judgment is different, but it sounds enough like it to where I think I should explain this. But, I've had a client before who contacts me and says, look, Steve, I'm being sued over a loan. Give an example. Client buys something on time. They miss some payments and they're being sued and they're in court now and they want me to defend them. So I show up in court and I talk to the lender's attorney and I say, look, my client wants to make this good. What can we do? And they say, well, we need a judgment against your person. And I say, okay, my client wants to make this good, but they can't make it good immediately. Can they make payments? I think you can immediately spot what their argument's going to be. We tried that before and they failed. So if we agree to it a second time, we're doing that thing where we're doing the same thing expecting different results. And so what I always say is, I say, well, no, here's the deal. My client will sign a consent judgment. And a consent judgment is one where we'll actually draft a judgment now. And we'll sign it and say, we agree to this judgment being entered if we default on a term, and these are the terms that they can happen on. And if the default happens, you then get a judgment for this. The difference between a confession of judgment and a consent judgment, there's several, but the most obvious one is there's attorneys on both sides of that document working it out. I'm consulting with my client, they're consulting with their client, and both parties say this is the best way to resolve this dispute right now. A confession of judgment is drafted by one side and said, here, take it or leave it. And number two, there's no dispute yet. So how can you consent to a judgment or confess to a judgment against yourself when you don't even know what the underlying dispute's going to be? And that's one of the things these people raise over and over again. They go, we weren't even in default. We were making all our payments, and they just took a judgment against us. And they pointed out that sometimes the way the confession of judgment's written, they make more money if they turn it into a judgment faster and just seize stuff from you than if they actually waited out and had you make all your payments. So in my situations, I think I've done consent judgments maybe half a dozen times in my entire career. I've heard of other people doing them, and more often than not, the clients, the people who are being sued, get it taken care of, and the consent judgment never gets entered. So the consent judgment is sitting there as a threat, hanging over their heads, but since they made all the payments, it goes away, okay? And as you can imagine, a consent judgment is also being created in a currently pending legal action. So if a dispute arose, if my opposing counsel said, hey, Steve, we're going to enter that consent judgment, and if I said, but wait a second, my client says they made all the payments, we could go into court in front of the judge who was identified in the previous court action, because it's a pending current court action, and ask the judge to resolve whatever dispute we had before the consent judgment gets entered. It would still get entered, but the judge would be able to resolve that dispute. A lot of the people that the Bloomberg Businessweek reporters spoke to said, we never had an opportunity to argue about any of this because they didn't even notify us that they thought we were in default. They just simply, the first thing we heard that there was a problem was money got taken out of our account. Okay, and you might say, well, Steve, how fast does that happen? Well, it turns out that New York has a couple other strange laws, and one of which is they have New York City marshals, not federal marshals, not state marshals, but New York City has its own marshals. And under some extremely archaic laws, the marshals are allowed to execute on judgments, and they get to do it for a 5% fee. But they don't take the fee from the person who holds the judgment. They take the fee from the person they're collecting the judgment from. So if they have a judgment for $100, they can take $105 from you, put $5 in their pocket, and hand the $100 to the person who had the judgment. And they point out in the article, again, they did some great work in this article, that the office of New York City Marshal dates back to Dutch colonial days by a decree of Peter Stuyvesant's council. And there have been some people who have suggested that the New York City Marshal's position probably is archaic, but it's still there. So what often happens is somebody who's in another state, Florida, Georgia, California, signs one of these confessions of judgment, and they're making their payments, or they think they are. They're making their payments, and then all of a sudden, out of the blue one day, their account gets frozen, and they're thinking to themselves, how'd that happen? I'm in California, and my account just got frozen. Well, what probably happened is the New York City Marshal, taking the judgment that they got through the confession, simply walked into a New York City branch of your bank in California and said, we've got this judgment against one of your customers. They hand the judgment to the legal department. The legal department goes, let's see, do we have an account with him? Yes, we do. Judgment looks good. It's been stamped by a clerk. There you go. And they just take the money out, gone. So that's how that works. And some of the examples they give in the story are astounding, including one person in Florida, I believe, who was holding money for landlords. In other words, they were acting as the agent for landlords and landlord-tenant situations. And a lot of the money that got taken didn't even belong to that person. It belonged to other people. There's a potential problem there because you're supposed to keep that kind of money sequestered. But that's another story altogether. So basically what we're talking about here, like I said, is a confession of judgment. So if you're tempted to sign one, don't. If you don't like my advice, don't. Then consult with your business attorney or consult with an attorney to find out if it's a good idea, because the second opinion you're going to get is going to be don't. But understand that if you disregard that advice, disregard the advice of the other attorney, and you decide that you're going to actually sign a confession of judgment because you need this money really, really badly, understand what can happen. And that is, without even notifying you that there is even a potential that they say you're in default, they can just say, we're going to turn this into a judgment. They walk into a clerk's office, clerk looks at the piece of paper, clerk looks at the affidavit, goes, okay, rubber stamp, boom, there's now a judgment against you. And if you've got banks in New York City, branches of the bank that you have in your hometown where you do your banking, you might be losing a bunch of money, and you will not have a chance to fight any of this. Now, as they pointed out in the article, if you wanted to, you could fight some of this stuff. But trying to fight stuff post-judgment is extremely difficult because you can't just raise every argument under the sun post-judgment. You're considered to have waived many of your arguments. And one of the biggest problems you're going to have is, I suspect that the courts of New York view these confessions of judgment kind of like consent judgments. You agreed to this. You signed that document. It's extremely difficult to go into court, and when the other side shows the judge a piece of paper, it's got your signature on it. It's very, very difficult for you to go into court and go, Your Honor, I disagree with that piece of paper. You didn't disagree with it when you signed it, okay? And that's your problem. So can you fight this? Yeah, you can try, but you're trying to dig yourself out of a hole because there's a judgment that's been entered against you. You consented to it, and the money's gone. So if you could go to court and prove the consent judgment or the confession of judgment was entered inappropriately, you might be able to try working your way out of it. But they interviewed other attorneys who've tried, and they pointed out that it's such an uphill battle that even though you might be fighting over tens of thousands, if not hundreds of thousands of dollars, it's kind of like you can try, but something the best advice here was you shouldn't have done it in the first place. So again, I've got to thank the guys who wrote the article and thank David for tipping me off to it, but Zachary Miter and Zeke Foe, I hope I'm pronouncing that correctly, and I apologize if I'm not, but I'll put the link to their article in the description below. But again, confessions of judgment, do not sign them. Doesn't matter how much money you think you need, you don't need that much. Questions or comments, as always, shoot me below. Talk to you later. Bye-bye.